at a dinner function, I raised this particular question about federal-state relations in my conversation with a ruler who is still living today. He's very concerned about federal-state relations. And I mentioned to him that as a man who was involved in the government, probably it was not in my place to suggest that a review was in order to re-examine the relationship between the states and the federal government, and in fact to review the federal constitution insofar as it relates to relations between states and the federal government. It will not be my position to state things which are really out of the ambit of my jurisdiction and function. But I did suggest to him that the best way to bring this matter forward will be to propose a review, if not through the state legislatures. Perhaps it should be brought at the rulers' conference, because after all, the Federation of Malaya Agreement was signed by the rulers in 1947, if I'm not mistaken. And during that time, we do not see things that are happening today, And I don't think the framers of the agreement or the constitution of the Federation of Malaya then foresaw what was going to happen at the time when the Federation of Malaya Agreement was drafted. And I said, it is high time that we have a relook at this and see whether the arrangements that have been put in place befit the situations that we face today. There's an urgent need for us to look at this again in order to ensure that the Federation survives, that the Federation is workable, that the Federation is going to function effectively in order to protect the rights of the people and the sovereignty of the states that have joined to form this Federation. We saw review taking place elsewhere, Canada, United States even, Australia, although not in the form and the manner that I have attempted to suggest here. But attempts were made in order to relook at those arrangements. And of course, we should emulate all those precedents that were embarked upon by people who were there before us and who we think know more about what should be done about a working federation. Malaysia was formed in 1963 when the 11 states of the previous Malayan Federation came together with Sabah, Sarawak, and Singapore to create the Federation of Malaysia. Federation is a system of government in which legislative power is divided between a central or federal legislature and a number of state legislatures. Both levels of government derive their authority from a written constitution. Unlike in a unitary state, sovereignty in a federal state is decentralized. Thus, the rights of citizens are secured at two levels, federal and state. In Malaysia, federation was a way to accommodate the different histories and pre-existing sovereignty of the member states of the federation. Federalism is a way of dividing and sharing power. In the system envisaged in our constitution, this division and sharing of power is part of a system of checks and balances meant to protect the rights and freedoms of our citizens. The separation of powers between the judiciary, the legislature, and the executive are part of that complex interlocking system. People often remark at how complex this country is.
What I'm interested in is all power should be limited. And if the power cannot be absolutely limited, then at the very least, power should not be concentrated. Power should be diffused to various centers. People power must be given emphasis. So prima facie, I support states' rights as an example of how power should not be concentrated in the center. Similarly, I support local government suffrage. Being a proud son of Penang, I am acutely conscious of how well local government did in the City Council of Georgetown, of how much the people of Penang benefited from a freely elected town council and subsequently a city council. But then, of course, the Prime Minister says we have too much politics. One example where a police chief can make a difference was in 1988, when the Tun Hamid or Tan Sri Hamid Omar Tribunal was sitting to decide the fate of Saleh Abbas, and Saleh Abbas rushed to the Supreme Court and got an order staying the deliberations of that tribunal, and Hamid Omar ordered the gates of Parliament to be closed. The lawyers of Tun Saleh went to see Hanif Omar, who was then the IGP, and Hanif Omar ordered the policemen on duty at Parliament House to ensure that the gates were open to allow the lawyers to come in and serve the order on the tribunal. So that is an example of where the police are people-friendly in the sense that they obey the law and not persons in power. Where the police themselves uphold the law, the rule of law, uphold what the courts do. The courts and the civil service as well are an important factor as well. The civil service particularly should be aware that it is the servant, if it's a state civil servant, he is the servant of the state government and the people of the state. He's not a servant of the federal government, even though he might be seconded from the federal service. And I'd particularly like to stress that state governments that come into conflict with the federal government find that they cannot rely on their state legal advisor to give them impartial advice, because the first loyalty of the state legal advisor seems to be to the head of his, what he considers his or her service, the Attorney General, rather than to the Ministry of the state. And this is something that should change. This is something that is against the present general orders and is against the present constitutional arrangements themselves. But until people in power change, until they realize what is right and wrong, things are going to remain the same.
But the fact is, we've had recognition by the executive that the judiciary is in a serious need of repair. What we've seen are KPIs, we've seen some cosmetic changes, we've seen some efforts to try and make the courts more efficient, all of which I'm thankful for. But at the same time, we still have a series of very, very troublesome decisions in the last, ever since this current Chief Justice came in. Enough for us to be very worried about whether in fact there is actually a true reform happening within the judiciary. Enough for us to say that, well, we can start talking about other things like whether the state should be given more power or not. So I think when we consider this, we must consider what exactly is going on in that sphere. Because ultimately, in as much as you and I may discuss what the Constitution says and what we think the states are about or what the federal system is all about, ultimately we may be wrong, according to the judiciary. And the Perak issue shows that very clearly. You have, I think, Tengku Razali, Haji Sulaiman and I sharing pretty much the same view about what happened in Perak, but we're all wrong. My point is, any government, that the federal-state compact was aimed at ensuring that while the federation itself was governed in a way that was good for the federation as a whole, the state governments were to be left free to deal with the problems of their own people to the extent that they could. And obviously we've seen that system failing in what we have.